Okay, go
And you
ahead.
have our contact information there below as well. And we'll also put that up at the end in case you want to reach out. So
Okay, so options, alternatives. We're gonna have a quick overview of the H-1B visa. Please keep in mind, this is not a seminar or webinar to tell you how to do an H-1B or what are the steps or the requirements in detail. We just want to give you an idea because today we're going to talk about alternatives. What can you do if you're not able to get an H-1B CAT petition for this year, or you're considering to do it next year? And you can see there's a lot of letters there, but we're going to talk about each one of them briefly.
So just to briefly go over the H-1B overview, what are we talking about? When we talk about the H-1B, it's a non-immigrant temporary visa that will allow workers to be in the US for up to 6 years. So the initial will be for 3 years, and then we can always seek an extension for the additional 3 years for the max of 6 years. And this is reserved for what immigration has identified as specialty occupations. And the H-1B will allow the employee, the sponsored employee, to work solely for that petitioner in the specialty occupation work that's identified. Now, specialty occupation you'll see is in bold and quotation marks because immigration is very clear in the regulations of how they define and what they will consider to be a specialty occupation. And the definition does say it requires highly skilled, specialized knowledge and requires a bachelor's degree or higher, or in most cases, the foreign equivalent in a specific specialty as the minimum entry into that specific occupation. So many years ago, we were able to secure H-1Bs for people with general business degrees. Since then, the government has gone back to the regulation and said, you know what? General business degrees are not specialty occupation. There has to be a specific specialty. And so if you talk to people who had H-1B many years ago and they'll say, oh, I was able to get it with my general business degree. That was true, perhaps then, but now that is very much a clearly defined aspect that immigration will look into and highly scrutinizes what it is in terms of specific specialty, and of course requiring the minimum bachelor's degree for entry into the position.
And that is a great point because one of the occupations in the IT industry, H-1Bs are used very frequently, but one of the occupations that they downgraded a couple of years ago is computer programmers. In their books, and actually in most colleges now, people can obtain a computer programmer degree, an associate's degree. Even people without any degrees can program computers. So for immigration purposes, a computer programmer degree, it's not equivalent to a specialty occupation degree.
Exactly. So you'll see the requirements there a little bit more delineated: U.S. bachelor's or higher degree or foreign equivalent. Education and training in the specialty field can qualify under H-1B analysis. There is the 3-to-1 rule. So for every 3 years of experience, so long as it's properly qualified, we could basically attain that 1 year of experience of the degree requirement. So essentially 12 years experience could, if properly documented and supported, be the equivalent of the U.S. bachelor's degree for the minimum entry into the position. Those cases are few and far between. They can be done. We always mention the caveat of it's got to be well documented, well supported. And then, of course, there are certain occupations that will require licensure. I think the most obvious would be with physicians.
In the healthcare industry.
In the healthcare industry. Engineers, sometimes we'll see the state licensure requirement. There are a lot of exceptions for engineers in practice where they will not require a license. Sometimes we have to bring that to the attention of immigration and explain that your particular state may not require it, but just a couple of things to keep in mind. And then let's see, why are you here? You're here because of numerical limitations. Let me get you to the next slide. So the quota is for 65,000 new H-1Bs per fiscal year. So fiscal year with the US, of course, we begin October 1st. That's our fiscal year. And then September 30th of the following year. So 65,000, that is not a lot. Obviously, this is a highly sought visa category. And that's why we are here. That's why there is a lottery. That's why we go through this. Now, there's 20,000 per fiscal year for US master's degree. Now, we have to specify it's for US master's degree, not for foreign equivalent. So where you've seen foreign equivalent in other sections regarding H-1B, the 20,000 reserved for US master's degrees is just that, a US institution of higher education, a US university that accorded you that master's degree. It applies for first-time H-1B cap subject, H-1B employees. We are not discussing H-1B cap exempt yet, but the numerical limitations are probably why you're even tuned into this webinar to see your alternatives, because you perhaps were not selected in the first round of H-1B selection that just happened. So the H-1B lottery, here we are. The lottery system registration was required. If you visited our previous webinars, there was a change to the H-1B selection process. This was, I think 2 years ago now, that we have the registration process that was implemented. That window began March 1st and it closed on March 18th
This year.
of this year. I think we have 2021 still up here. So it
I'm
should
so
be,
sorry.
it'd be 2022. But then random selection occurred March 18th of 2022 until September 30th. So chances are, if you were selected, you heard from your attorney between now and then. And that's where we are. So now, if you were selected, we will be filing for your H-1B cap subject case between April 1st of 2022 until June 30th, 2022. Last year, and that's where you have the 3 lotteries there with the question mark, there were 3 lotteries that took place. So the first round went through. It seems that when they processed the applications, there were visas that were available that were not utilized. And so then we had the second round that happened in July. And then even later than that, we had a third November, which was of 2021. We had the last round of 2021 selections that were notified in November for that fiscal year. So here we are. That's where
so if you apply for the lottery this year and you have not been selected, don't lose your hope, because you might be selected. Who knows? We might have a second lottery and even a third one. We will not know until after July, because then remember, people have until June 30th to file the H-1Bs that were selected. And then if they don't receive all the applications, or if they have duplicates and they had to deny registrations, they might do another selection, and we will know sometime in August. So keep your fingers crossed.
Yes. So that brings us to H-1B cap exempt employers. So the H-1B cap is what we just discussed. That's why there's numerical limitations that your employers are limited to, but the regulations do allow for cap exempt employers. So in other words, you're still doing specialty occupation work. You're still working exclusively for that petitioner at the work sites that are designated, but it could be that your employer will qualify to be considered cap exempt. And you'll see right there on your screen, it's government research and nonprofit petitioners affiliated. So that's key, the affiliation with government research institutions. Institutions of higher education, universities and colleges may apply. Now, the regulations are very specific about who meets or what institutions will meet that higher education definition. So we always tell folks to please have your employers contact us, and we can go through and see if they would in fact fit that definition to be considered a cap exempt employer. The other one, which is great, nonprofit petitioners affiliated with institutions of higher education. This can be a little sticky, sometimes showing that affiliation can require quite a bit of documentation, but if the affiliation exists, we may have to go through an RFE, maybe 2. But if we can show it, then you could be cap exempt with that employer.
Yeah, a perfect example for that, it might be a teaching hospital that is nonprofit. We see that a lot with some of our clients. They are nonprofit, and they also have agreements with medical schools nursing schools where the students come and train, that would definitely meet the definition of a nonprofit affiliated, and therefore they could sponsor people, not necessarily doctors and nurses and healthcare person, but remember, these institutions also need accountants, engineers, computer people, marketing people. There's a whole selection of employments or different employments that's not just healthcare related, but if they are exempt, they can sponsor people at any time of the year.
Right. So we just say don't be quick to discount that the employer may not be CAP exempt. And then the last one is a really great exception is for for-profit employers. So say you're not nonprofit, you're not affiliated with government research, you're not going to fit one of those 3 or 4 mentioned. If it's a for-profit employer, but the placement of the employee, the work location is a nonprofit facility that's affiliated with institutions of higher education, we could get your H-1B employee to qualify as CAP exempt. Now, the H-1B work, I think the definition says it has to be at least 50% of the time is spent at that facility. Angela and I like to emphasize that it be at least 51% because
we don't want any doubts.
Yes. So look at your petitioner, look at the potential employer. It could be we might be able to fit them under one of the CAP exempt definitions.
And that's the first option. Look for an employer that qualifies as a CAP exempt so you can get your H-1B. Now, then we look at employees who might be exempt. This is not just the employer. Here is the employer is subject, like the private entity that wants to sponsor you, but then we look at the individuals. And the first group to think of, because we work a lot with these individuals, are J-1 waiver physicians. For those who are not familiar with this, physicians in general come to this country for training purposes under a very specific visa, which is the J-1. That is for training. And they do the residencies or fellowship training programs. And then to stay in the United States, because the J-1 visa requires them to go back home for at least 2 years once they complete the program. So if they want to remain in the United States, they have to obtain a waiver. We're not going to be talking about the different programs for waivers because this is not about J-1 waivers, but once they obtain that waiver through one of the agencies, exempt, there's a waiver, an option for hardship waivers, and those are not included in this category. So a physician who has a J-1 waiver is exempt from the H-1B numerical limitation. Therefore, the employer that sponsored that waiver can file the H-1B visa at any time, whether a private or public entity, it doesn't matter because the physician himself or herself is not subject to that numerical limitation. We also have we have some information here about waivers, 3 years to start employment. The physician has to commit to or sign an employment agreement for 3 years, but J-1 waiver physicians in general, they're not subject. Then you have the H-1B concurrent employment. So for example, you are with an entity that is CAP exempt, you have your job at a university or a for-profit, a non-profit that is affiliated. So you have your full-time employment with that entity, and now you have an opportunity to work part-time with somebody else. But happens that that somebody else or that other employer is CAP subject. Technically, you couldn't, but because it's concurrent employment, meaning you will keep your primary job, which is the CAP exempt job in H-1B, and then you can do part-time with anybody, any other entity, CAP or not CAP exempt. So that's an option for people looking to kind of work more hours, or maybe the first or the primary employment in the H-1B is not full-time, because it happens. H-1B doesn't mean full-time. H-1B just means work authorization, full or part-time. But if your primary employer, your primary H-1B is CAP exempt, then you can have a concurrent employment with a CAP subject employer. Also, other people who are exempt from this is those who already were counted towards the H-1B, and I see that we didn't include it because it's pretty obvious. If you were already counted towards the cap and you're working with your employer who sponsor you for that H-1B and you got it, but a year from later you decide that you want to change employers, then you can change employers to any employer you wish because you're not subject to the cap any longer. When do we start thinking about alternatives? Well, the fact that you guys are here, that tells me you are already looking at alternatives. You can do it, and we always tell people from the first time you come to the United States and whenever visa, you might want to start looking into options if your desire is to stay in the United States, live and work. So good timing is my H-1B was not selected, or at least in the first round, who knows if there is a second or third. My H-1B was denied because it happens, or I am at my maximum 6 years of H-1B. And to that effect, we do have a question that kind of covers both. One of the questions is, if I complete my 6 years, do I have to leave the United States, or the fact that I went to school and stay in school for 2 years, an F visa, meaning the person has not left the United States, can I again obtain another H-1B? For the new H-1B to be able, for you to obtain a new H-1B after you meet the 6 years limit, then you have to leave the United States. Not that you're not in H-1B for a year or 2 years, is that you're not in the United States. So you have to leave the United States for a year to be able to start working and get those 6 years again. But then you're subject to the cap. So it's not, I met my 6 years, what do I do is you're subject to the cap, you have to live for 1 more year.
Yeah, it's the departure of 1 year.
Okay. Other options. So we're here and we're going to talk about other options. We talked about employers and employees and when to start looking. So now we're going to go into other options. H-1B1. And this is for based on the Free Trade Act between Singapore and Chile and the United States. They're out of those 65,000 visas that Michelle mentioned at the beginning. The USCIS reserves 6,800 visas exclusively for nationals from Chile and Singapore. For nationals of Chile, they have 1,400, and for nationals of Singapore, 5,400. It is limited to 18 months initially. It can be extended or it can change to H-1B status. Dependents cannot work and there is no dual intent. When you have an H-1B visa, you can at the same time of being in H-1B, be processing your green card. When you have an H-1B, you cannot have the intent to get a green card. The minute you start filing documentation that shows your intention to become a green card holder, you lose the ability to renew this H-1B1. How do we know how many visas are available? Well, let me tell you, if you go to the Department of State, there's no data. If you contact and try to find information out through the Department of Immigration, there's no data. We go to the consulates in Chile and in Singapore, they keep track of it. Usually there are visas available because these are not visas that if you don't use during the fiscal years, you lose them. These are visas that whatever is not used during the fiscal year, which is October 1st to September 30th, then it rolls over to the next year. So every single fiscal year starts for Chile with 1,400 visas and for Singapore for 6,800. And if there were visas left from the previous years, they are added up to those visas. So right now we're working on a couple of H-1B1s, and
which is a great option for for folks from those countries.
Yes, and we understand there are visas available because the consulate in Chile, these are Chile, confirmed that they have visas available. We do not know how many exactly. So we just hope that by the time we get our petitions in, we still have visas available.
Okay, so if you're not from Chile or Singapore, but you perhaps still have a university career you can continue, consider the F1. The F1, if you're starting, for example, a master's degree program because you had just finished your bachelor's degree program, you could consider, because that will reset so you could have at least 1 year of employment authorization post-graduation from your master's degree. So university students, this is something that we often talk to them about, is consider going back to your F1. There's obviously no requirement of what employer, because you would be given the EAD. Obviously, you want to stay in the area of the field that you studied. That's one of the requirements. And if it's in a STEM, degree, if that's what you have, and your employer's E-Verify, you could also qualify for the extension of up to 24 months. So what happens during the OPT period? You could try again for the H-1B cap if you don't make it, but you have a STEM degree, and you can seek the extension because the sponsoring employer is E-Verify. You will have at least 2 other bites at the apple. So definitely a huge encouragement to consider STEM programs and look at this F1 option for the OPT at the master's level, or and the extensions thereafter.
Just keep in mind that with F visas, you are entitled to an OPT or EAD per degree. So for example, if you completed your bachelor's degree, you tried for the lottery, you didn't get it. If you have the capabilities to go back to school and do a master's, that's going to buy you 1 more year or 2 years, depending on what master or the program lasts. And then at the end of that master's, you can get another OPT.
Exactly.
And hopefully with an E-Verify company, so you can extend it you have OPT for 36 months rather than 12 months.
So 3 potential cap attempts as well. So that's also the good catch on that one. If you're not looking at that, but you happen to be a citizen of Australia, we have the stepsister of the H-1B. And I say stepsister because a lot of it looks like an H-1B, but it's not, because the E3 is available for citizens of Australia. They have that specialty occupation requirement. So very similar to the H-1B, it's got to be in a specialty occupation. Go back and look at the requirements, bachelor's degree, and for entry in a specific specialty into the occupation. The annual quota is never met. The approval will give you a 2-year period, and spouses are eligible to work get an employment authorization document as the dependent. The trick is the E3 is not dual intent like the H-1B. It's very much non-immigrant, and most of these are applied directly through the consulate. So we will do lots of basically H-1B specialty occupation analysis, but is this specifically for Australians? It's E3. It's an option that many Australians will try, because once we have you in a specialty occupation, if they're with that employer, we still try for the H-1B so they can get into that dual intent visa category. So if you're from Australia, there you go. This one is one that we work with often, and it could be our proximity to Mexico because we're based out of Texas. Of course, we take clients all over the country.
The world.
Or the world. But if you're a citizen of Canada or Mexico, and you're on the specific, and you'll see the reference there for the regulation on a specific profession, right? These are for these professionals in these occupational fields that are identified. You can qualify for the TN visa. This was previously under NAFTA, but now it's the United States, Mexico, Canada Agreement, USMCA. We've had that for a couple of years now. The approval will be for, depending on visa reciprocity with Mexico and the US, limited to what they indicate. If we seek the approval here within the US, you can get up to 3 years. That's just what it is. It's a dual intent. I'm sorry, it's not dual intent. It's strictly non-immigrant. There's no cap. So you could essentially continue on extensions for not infinite extensions, but there's no cap on it. There's no limit that, you know, you have to go out and come back in after some certain amount of time. Dependents are allowed to come in on TD status, but they are not granted work authorization. So unlike the E3 spouse, the TN spouse that would come in on TD would not be employment authorized. So that's a little bit limiting on that one. But if you're in these occupations, engineers, accountants, there's a whole list of them. There's even some that are a little trickier, but we can oftentimes, if you have the credentials, we could definitely look at the TN if you're Canadian or Mexican.
Okay, so now we go on to the E2 treaty investor. One of our favorites too, and we do quite a few of these on a yearly basis. E2 visa investors. This is for individuals who want to come to invest in the United States. We're talking money, okay? This is different from the E1 treaty trader. The bases are kind of the same, but for the treaty trader is I have been importing or exporting items or goods, and that is about volume. And you have to have at least 1 year of records to show the volume of items that you have been importing or exporting to be able to look into the E1. So for that one, we're not going to touch much on that one, because the one that will give you access to a visa sooner is the E2. There is no 1 year requirement or anything similar. It is just about how much money you're going to invest in the United States, what type of business, whether or not it's going to benefit the United States. A spouse can work, and we have a new latest changes from the Department of Immigration, where they are really doing great service to E and L spouses, dependents, because now they are, and we can address that at the end. But going back to the investor, so you must be the owner or employee, and you must be employed with the organization. You can also bring employees and its status but that's part of the investment. You can't just come as an owner, as an E2 to manage your business, at the same time bring 1 or 2 or 3 employees, because the business has to be operational and functioning and have earnings to justify employees to come on E status. So for the owner of the company, the investment must be substantial, real, in an enterprise, and it cannot be marginal. What does that mean? It means that a $10,000 investment will not give you a visa. But also you have to look at the type of business you're going to open. We always give examples. If you tell me you're going to open a business where you're going to be selling cars, well, we're talking about a lot of money, because just one car costs money. But if you say, well, I'm a retail and I'm going to open a store, well, it's a different type of investment, but also is money. So we usually ask, the regulations don't require, but USCIS now gotten used to practitioners including a business plan. We always ask for a business plan, 5 years, and you have to outline what is your business, what is the competition, where you're going to open, who is your market, and projections for 5 years. How much you're going to invest in the first year, what is the total investment, and prorated to the total fee investment in 5 years is that you have to have your initial investment. Definitely only for people who are from countries that have treaties with the United States. And if you have a partnership, which you can, the people in the partnership, they have to be from the same treaty country. But for you to be able to obtain an E2 investor visa, you have to have control over the business. The regulations specify 50% or more. We usually recommend people to get more than 50%. Why? Because if you have 2 partners If it's you and somebody else. If it is 3, fine, you have 50% no matter, you rule. But if there's only 2 partners and there is a dispute, who's gonna break the tie? So 50%, yes, will get you in, but it might not give you a lot of control over the business. So think about that. Essential personnel, professionals or managerial positions. We're talking about, one of the elements is, if you say, I'm going to open a business and I'm going to manage the business, you have to be able to show to the Department of Immigration that you can operate the business, that you have some sort of knowledge or experience, or certain qualifications. We're not talking degrees, because here it doesn't matter. What matters is what knowledge or experience do you have managing a business, not necessarily this type of business, but a business that you can say the chances that the business is going to be successful because I'm there is higher than not. So you have to show that you are able to manage the business. Spouses can work, and there's no dual intent, unfortunately. Extraordinary abilities, we're going to go with that one next. The O1 visa is very popular. However, the criteria for an O1 visa is a little bit stringent. It's very specific. This is for people who, in general, have risen to the top of the field. They are above average. Certainly, I'm not extraordinary ability, although I'm a lawyer, and I might think of, but no, I'm a very normal average person. We're talking people who have sustained national or international acclaim in the field of endeavor. Field, what field? You have to define your field, and you can tell me, well, I'm an engineer. Well, it's a broad field, but what type of engineer? Well, I might be the only engineer who does this. Well, then there's no competition, so there's no way to measure how good you are, because if you're the only one, that's not going to work. So, but your field, and then when you can give us examples, and usually you have to have support letters from other peers talking about your accomplishments and why you are above average. You have to have an employer. This visa requires you to have an employer in the United States. Even it could be through your own enterprise. You can create your own company, and your company will sponsor you to come to the United States, but you will be an employee of your company, or an agent for certain individuals. Initial period of a visa is 3 years, but it can be extended unlimited. So you can renew your O1 visa indefinitely. I met a person who had O1 visa for 20 years and finally got the green card through the employer. And I don't know why they waited so long, but 20 years on an O visa. Of course, he had to sustain and maintain his extraordinary ability through all those years, meaning continuing to do what made him extraordinary so he could get that extension. Because every time you file, you have to prove the same elements. Dependents cannot work, and is dual intent. Fortunately, it's similar to the H-1B. You can have a green card going at the same time you have your O status.
So the L1 intracompany transferee, this one is very challenging at times. Now, you could meet the requirements, but know that USCIS has put a great deal of scrutiny under these applications. It's just like it is employer specific. It requires that the applicant, the employee, have been at least 1 year of employment within the 3 years of filing. So you could look back 3 years and have at least 1 year of employment in a managerial or executive capacity, or even specialized occupation abroad for the company, the foreign company. Now, this foreign company has to have the US counterpart, right? Whether it's a parent, subsidiary, affiliation, or even a joint venture arrangement with the US counterpart. The idea is you're bringing that employee from the foreign entity in that one of those capacities to another L1, to the managerial, executive, or specialized, basically specialized knowledge capacity in the US entity. So I always tell folks, think of large corporations, think your PepsiCo's, your Coca-Cola's, you have a manager, country manager in Mexico, you want to bring them over to the managerial position in the US. That's the idea. Now, obviously, the L1A or the L1B is going to contemplate smaller organizations, but that's the way we sort of try to explain what we're talking about. We're taking someone from the affiliated or from the related company abroad, bring them over here. It's a 5-year maximum if we're doing L1B, which is specialized knowledge, or 7 years if we're talking about an L1A, which is either in a managerial or an executive capacity. Now, managerial and executive capacity is very strictly defined in the regulations, and you will find that that's where immigration oftentimes will try to pick apart and find out, was the position abroad genuinely managerial or executive, and is the position that they're coming to take over here with the US counterpart managerial or executive, or in some cases specialized knowledge. So they are challenging because they are very much coveted and sought after. The L visa is a dual intent visa. Oftentimes company or folks who don't come from countries that have treaties with the US so that they could qualify for the E1 or E2 are limited to looking at this L1 as an option. Again, it's also highly coveted because the spouse can come over and obtain work authorization through the L1 as well. So it can lead, if we're talking about managerial or executive capacity, L1A, it could lead to the green card through the EB1C, multinational executive. So the L1 is highly sought after because it does have a pathway to the green card. So again, highly scrutinized. We definitely look at these very carefully to see if you would qualify.
We then have the J1 exchange visitor. This is different from the J1 I was talking for physicians, although they have kind of the same elements. This is for non-immigrant visas, obviously. It is for people with knowledge, skills, in the fields of education, arts, and science. So it abarks a great field. Pretty much any occupation, any person trying to do some additional training or coming to the United States to learn a little further their skills might be able to get a J1 visa. No dual intent, meaning you cannot be applying for a green card at the same time you have a J1. Some individuals, depending on the countries and the occupations that they have, might be subject to the 2-year home country residency requirement. What that means. And I briefly mentioned this at the beginning with physicians when they come for training. If they are doing training through the ECFMG, they are subject to the 2-year foreign residency and they can obtain waivers. Same here. There are certain occupations, and there's a list of in the Department of State where you can see what countries and what occupations, depending on the country the individuals come from, they will be subject to going back home for 2 years. Usually when you get a visa, a J1 visa, on the face and the little stamp they put on your passport with the visa, it says subject to the 212E requirements, which is 2-year foreign residency. But that might be deceiving because frequently we've seen that agents, consular agents, officers might make mistakes, and sometimes they say you're subject, and when we look it up, the regulations and everything, we find out people are not subject, or sometimes they say they are not subject, and then when we start looking into the requirements, the person is subject, not because the officer makes a mistake means you're not subject. If you're subject, regardless of what the visa says.
Exactly. So if there's an error on that visa imprint, that they won't excuse that. It's just, well, the program
you will not be able to blame the officer and then get out of the 2-year obligation. You are obligated regardless. Spouses and children can come to the United States. Spouses can work. They can obtain work authorization. Children don't, but they can go to school regularly. Waivers available? Yes, usually is the no objection waiver. That's another type. We'll do a webinar on waivers some other day. Some of the programs that might be included for these J1 visas. You see au pairs, they frequently come, and J1s, government visitors, physicians, and I mentioned those because that's a great part of our clients, camp counselors, interns, professors, and researchers. We have a lot of those as well. Short-term scholars, students in college, university, summer work, travel. The visa might be for as little as 3 weeks, as several years, depending on how long the J1 program lasts. So you have the list there. Then we have another one that is underutilized as far as I understand, but it's very useful. The only issue here is the H3 trainee visa is that employers must have a program in place to sponsor somebody for an H3. And it's training, like similar to the J1, but it's different in terms that you're not required to go back home for 2 years. And you're gonna do training and might do some work, and you might even be paid, but related to the work or the training you're doing, because it's not necessarily productive employment, which means you might get an H3 visa, but not necessarily being paid, because that's not an element of this visa. It is strictly to get knowledge and training. And again, you might get paid, but incidental to the training you're doing, but not because it's a requirement. It is for 2 years and there are no extensions. So you're looking just to be here, get some training or experience. This might be a good program. Remember, the employer has to have a very well put together program and submit documentation with the Department of Immigration showing that you're going to be learning not just hands-on training, but also some sort of classroom kind of instruction. Dependents, spouses cannot work, and again, no dual intent. I think that from all of these visas, pretty much the only ones that have dual intent are the L and the H-1B, because the others don't have dual intent. Then we go next with this beautiful one.
B1 in lieu of H-1B. This one,
very, very, very well utilized. People get it all the time.
Yes, and there was a little bit of an uproar because the previous administration back in October 2020 had sought to eliminate it. The most current administration said they're not going to pursue the elimination of this one because it is one that is sought after by quite a few. And it's basically for your foreign national that would otherwise qualify for an H-1B. They're coming into the US to perform H-1B services, but they're going to stay on payroll and they remain and will continue to be employees of the foreign company. And the term of the duration of which they're going to be here is going to be up to 1 year. There's no dual intent. The annotation will be very specific on the visa that's issued. And so the idea is that everyone has been transparent about the fact that there is work in a specialty occupation that's coming to be performed, but the employee remains the employee of the foreign entity. But the fact is they have to be here in the US to sort of carry that out. It's one that we've seen that will be issued and can be if it's properly documented and supported.
Yeah, I like to make a distinction here between this B1 and the B1 that people get at the port of entry to do business. When you apply for a visitor visa, frequently you get issued a visa that says B1, B2. And then when you come into the United States at the port of entry, you let the officer know what is your intention. Well, I'm coming to visit. So they write down as a stamp or I-94, B2, visitor. Or no, I'm coming to do business. So they'll do B1 and you come and do business and then you leave. It's very different from this B1 we're talking about, because this is kind of in place of an H-1B. What that means, you'll have to apply for this one at the consulate and your visa will read B1 and you will be authorized to stay in the United States for 1 year working on the B1, but very restricted. It's not H-1B full employment. It is under the specifications for B1 and only for the 1 year that you're allowed to be here. Different from the B1, I'm coming to do business, you come do business, sign a couple contracts, go back home, and fulfill the contracts that you signed or the agreements, and you're done. And you're not supposed to be working in the United States when you come in with that quick one and a B1 doing business as opposed to this one.
Yeah, oftentimes we'll see executives come in on the B1 to attend work conferences or seminars. There's no active employment. This is the one that sort of contemplates there's going to be some employment activity.
Yes. H4, employment authorization. You want to talk about this one, Michelle?
So H4 employment authorization, if you qualify, right? The regulations, you have to go back. This was one that has been in the news for several years, but certain H4 dependents of H-1B holders can apply for work authorization. The idea and the caveat is that the H-1B holder has an approved I-140. So we have an approved immigrant petition by the employer. And so long as we can show that those requirements are met, they can apply for work authorization, employment authorization. The term that will be issued will be concurrent with the H-1B visa holder. The idea is if you have work authorization, you can present that at any employer. You're not limited like your spouse would be with working with only the H-1B employer. If you have that EAD, you can go and work wherever that you can. It's not employer specific. Now, this one is interesting because we heard just a week ago that they will be implementing immigration. USCIS will be allowing for premium processing of EADs. This is going to be very helpful because the processing times our H4 EAD eligible clients have seen have been ridiculous. There's more to be, more to come regarding the when, the how, but we do know that it'll be a $1,500 processing fee, and it's supposed to happen this fiscal year. So by September 30th, we will have the details. As of right now, in this current webinar, we don't have those details, but that is forthcoming, which is great.
The other thing for the H4's EAD is that, and this was just released this couple of days ago, the Department of Immigration finally is coming through with some sort of relief for L's and E's, employment authorizations. For H4 specifically, now what they're going to do and they're doing is that people are going to be given an extension of the EAD. So for example, if you file for a renewal of your EAD timely, meaning before it expires, and you're still waiting, you would probably be seeing notices from the USCIS. They said April 1st, telling you that your EAD had been extended for an additional 180 days. So watch out for that. But the problem is that sometimes it's taking the Department of Immigration more than those 180 days to complete the process, but at least they're giving people a little bit of relief that they know once they file, they'll have an additional 180 days, and hopefully USCIS is going to approve the employment authorization of the renewal at that time. They also announced that for L2 and E dependents, spouses, that are no longer required to apply for employment authorizations in the United States, that actually once they obtain the status, whether because they come in an E or they file for change of status, then they are authorized. Just the status itself allows them to work. They might want to apply for work authorization as proof of employment, because some employers may not believe. What we are telling people is once we start getting this, and we have heard that even some people that are coming through at the airports or ports of entry, they are getting a stamp that they are some sort of code for work authorization. So is until people get used to see that E's and L's spouses don't require employment authorization, they might have to print the regulations and get the visa when they're working, getting a job, and they are asking for proof of employment, give them all those papers.
Exactly.
But some people might find it easier to get an EAD as proof of employment.
And this is welcome news, because for years we've been arguing that L2 and E dependent spouses are allowed work authorization pursuant to status. The regulations are very specific. This has been a battle that we've been having with USCIS for years. I think they acquiesced and said, yes, pursuant to the regulations, incident to status, you are employment authorized. You don't require that EAD. But as Angela said, that EAD for most employers, for practical purposes, they won't let you work. So you would want to get that EAD, but it's going to eliminate a lot of problems that we've had with arguing with employers about incident to status employment authorization.
We're going to go now on questions. We still have a few minutes left. And one question that somebody posted on our chat, it relates to the H-1B, whether if you are running out of your H-1B status, and the specific questions says, I have been in H-1B for about 4.5 years, and I changed to F1 status. And we addressed this one at the beginning of the webinar, but we're going to address it again, make sure this is clear. But I changed to F1 status. So if I want to go back to H-1B, since I have been in F1 status for more than a year, would I be able to get again the 6 years of H-1B term, or in other words, would my time reset for the H-1B getting an additional 6 years, or I can only work in H-1B for the remainder of the 1.5 years? Yes, the time doesn't reset, as we explained. If you want to get again those 6 years, you'll have to leave the United States for 1 year. The requirement is not to be in H-1B status for a year or longer. The requirement is not to be in the United States for at least 1 year, so you can apply it again and get those 6 years of H-1B status in effect. The downside of this is that you will be subject to the H-1B cap, but I understand you are already subject because you're working with an entity that is cap exempt. So you will continue to be cap exempt if you leave the United States for 1 year and get the 6 years back and start with H-1B.
But as you mentioned, you still get that 1.5 years and that 1 month that you were out. So you get to recapture that 1 month. So because you're already counted in the cap, you do get to pick up and finish that 1.5 years plus that 1 more month to finish out your H-1B.
Yes, you can still use that 1.5, but not total of 6. It doesn't reset.
Exactly.
I have another couple of questions that people submitted yesterday. I don't want to abuse your time, so we're going to do this quickly. One of those questions is, if I am in the United States in F1, can I change the status to H4 EAD? Well, first of all, you need to be married to an H1 holder to be able to apply for an H4. And then and you can file concurrently the H4 and the EAD petition. What we are seeing is that hopefully they will implement this premium processing soon, but in many cases what we are seeing is that the Department of Immigration approves the H4 and then the EAD takes longer to be completed, so people have to wait longer to get that EAD approved. But you can file them concurrently. If you didn't file them concurrently, you can file the EAD at any time, as long as, remember, H4 EAD requires that the H-1B holder has an approved I-140, which is an immigrant petition. With that approval, you can apply for your EAD H4, because that's a requirement, that your spouse is in H-1B and that the spouse has an I-140 approved, so you can obtain the EAD H4. Any more questions? I don't see any more questions in the chat, so then thank you so much for being with us today. We appreciate your time and kindness, and we'll see you again. Thank you.
Thank you. Bye-bye.